Hello, this is Matt on the Moon Lambo channel, and take a look at this headline from Finance Feeds. Ripple loses patience and wants court to sanction SEC. Whoa, how about that? And in fact, I'll just show you this here in the intro of the video. Look at this tweet from attorney Jeremy Hogan, and this is regarding the most recent legal filing from Ripple on an issue having to do with the Mets supplemental document. If you're not familiar with what that is, don't worry, I'll set the table for you. But look what attorney Jeremy Hogan had to say. He highlighted a few key words from Ripple: gamesmanship, prejudice, sanctions, and then he wrote, "I would say the gloves have come off." Yes, I agree with Jeremy there, and you'll see why. This is one of the more strongly worded papers I've ever seen. It's certainly a shift in tone compared to certain other legal filings. So I want to highlight that. And also, there's an organization called the Blockchain Association, which is supposed to be the unified voice for all in crypto. At least that's how they position themselves, and pushing for proper crypto-related regulation. Well, they just released a paper having specifically to do with the SEC's, let's just say, unsuccessful and inappropriate attempts at regulating the space. And this paper that they wrote, rather lengthy, didn't mention Ripple or XRP at all. So I'm going to share with you a few comments from the community on that, including something from attorney John Deaton. But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Credit to attorney James Filan, who shared this document all up on the Twitters. I'm going to share with you just some specifics from this, and then I'm going to jump into opinions from 3 different attorneys within the XRP community on this topic. So again, this is filed by Ripple's attorneys. Now, what is this about? Well, here you can see James Filan wrote, "Ripple, Chris Larsen, and Brad Garlinghouse have filed a letter in further support of their motion to strike the SEC's late-filed Mets supplemental expert report." So this has to do with a report that the SEC paid Dr. Metz to create. And the report, which is over 100 pages, came to the conclusion that XRP price action follows developments surrounding Ripple, which of course would make it look like more of a security of truth. Now, of course, that's not true. It can be provably shown that XRP just follows the broader moves of the crypto market, specifically led by Bitcoin. So it's methodologically flawed. And this guy got paid $600 an hour to put this damn thing together. Taxpayer funds. Think about that, $600 an hour. Ripple hired their own professionals and said, no, your methodology was incorrect. And after they cited the reasons that the methodology was incorrect, Dr. Metz came back and said, no, I've got a response to that. But that was filed too late. And that's where we pick up here. The SEC wants this to be considered within the case. And effectively, Ripple's attorneys are saying, no, it's outside of the timeline. And then they cited additional reasons that it would not be reasonable to have this supplemental information be considered. And specifically, they highlighted 4. So I want to kind of breeze through these, and I want to get into the opinions from the attorneys. Number 1, Dr. Metz's failure to anticipate a criticism of his inadequate opening report did not implicitly invite the SEC to file an untimely reply report. No kidding. Logic be damned, though, right? Number 2, the importance of Dr. Metz's report only serves to underscore the inexcusable quality of its delayed submission. I like that one right there. We'll see how the judge responds to that, but I personally, I was like, sting, yes. The importance of Dr. Metz's report only serves to underscore the inexcusable quality of its delayed submission. Yes, it's so important, and he was so irresponsible to not take care of this in a timely manner. Number 3, defendants, and this is my favorite one out of the 4, I think. Number 3, defendants would face great prejudice if this litigation, which has placed their business in limbo, is further delayed by reopening discovery. Defendants would need to marshal additional resources to address Dr. Metz's newly filed reply report when the parties ought instead to be focused on summary judgment practice, and the SEC would again be rewarded by further delaying resolution of the ultimate issues in this case. So it's clear to what they're saying here. If the judge grants this, you're basically reopening discovery, And then this would require Ripple to pay to have their experts come back in and have a reply issued as a result of that. Except for there seems to be some sort of precedent for perhaps the plaintiff having to pay for this if it's their action, or in this case inaction, that resulted in this set of circumstances. It might be the case that they have to pay for this. And so Ripple's attorneys, they actually cite a specific case that's relevant to this, and then they write the SEC's citation to, and then they name the case, is inapposite. The court there determined that the expert's supplemental report was a proper rule, 26E, correction to a mistake in the expert's earlier calculations. Acknowledging that even this mistake, although unintentional, caused prejudice to the defendant, the court required plaintiff to bear the cost of the continued depositions, including defendant's reasonable attorney's fees incurred in preparing for and taking the additional depositions. There you go. Ripple arguing, hey, the case that was cited previously by the SEC, which Ripple's attorneys brought up here, says, no, that's a bad reading of that. And in fact, you might, if you're going to apply the precedent, looks like perhaps the SEC should be paying for Ripple's attorney fees, and perhaps even for the additional development having to do with this prolonged discovery period. Number 4, a continuance would reward the SEC for its gamesmanship and further prejudice defendants. The SEC has already asked the court for numerous extensions in this case that defendants have vigorously opposed. So pause, you can see the tone in this is a bit different than what we're used to. I'm not complaining either. I personally find it a little scrumptious there. I don't mind that. I'm happy to see this. And then they continue. The SEC's decision to wait until after the very last deposition scheduled in this case to file Dr. Metz's new reply report necessitates sanctions. Oh. Rule 37 sanctions specifically serve to several important purposes, such as ensuring that a party will not benefit from its own failure to comply and serving as a general deterrent effect on the case at hand and on other litigation. So there you go. The SEC failing to comply, their own incompetence right here. And so Ripple's arguing their incompetence should not result in Ripple, the company, being prejudiced. It sounds reasonable on the surface. So I you know me, I think Ripple should win on this, but are they? Well, that's the question. Take a look at this. XRP Crypto Wolf responded to Jeremy Hogan on Twitter and wrote, Ripple should have taken the gloves off from the start. SEC plays dirty, but the XRP army has been digging up all the dirt. Ain't that the truth? XRP Crypto, I'm going to heart that one. Attorney Jeremy Hogan responded to that and wrote, I tend to agree with you. I think it was a mistake to agree that earlier extension because that's one less instance of an opposed request that Ripple can point to. After that one, Ripple told its lawyers, stop playing nice. And you may recall that there was an extension that Ripple didn't push back on, and I talked about it. I said, well, maybe it really is just the case that Ripple's picking and choosing their battles. It's not a very long extension. But here Jeremy Hogan's pointing out, well, since you didn't point that out as a problem, at this juncture in the case, before the trial actually starts, you can't really point to that specific one. But yeah, it does seem to be the case that Ripple's attorneys are writing in a materially different manner than they had. And to this point, I want to see more of that. I would love to see more of that. Put these little baby back brioches back in their place, little asshats hanging out at an asshat factory. Then there is this from Sherry V, responded to Jeremy Hogan's tweet and wrote, if the judge does approve the addition to Dr. Metz's report, I would imagine Ripple would need to reach out to at least one of the 3 experts they'd hired from Compass Lexicon. Doubtfully, Morai or Fischel, the 2 of the experts, would be cheap in writing up a newer report, assuming that's an option. And Jeremy Hogan wrote, it is an option, just not one I think the judge should allow, but she may make the SEC pay for it. Also, not what should happen in my opinion. Yeah, so it seems to be the opinion of the attorneys within the XRP community that the most reasonable thing here moving forward would just be to not allow Dr. Metz's supplemental report because it's outside the rules of the court. That's what seems reasonable here. Now here's attorney Fred Rispoli, member of the XRP community, and here's what he had to say about this. The fair ruling would be to exclude the late filed report, considering SEC filed it 2 hours from the deadline. My prediction is Judge Netburn allows it, but accelerates the timeline and makes SEC pay for everything related to it, probably $100,000. Anything else is a loss for Ripple. And I know that might sound outrageous, but that's because the cost for this lawsuit is outrageous completely. It's millions and probably tens of millions of dollars. And I kid you not. You can think about even the library case. Jeremy Kauffman, he publicly cited that they're already almost at 2 million in their case. It's not at the same scope, not to state that it's not as consequential or important, but it's not the same scope in terms of monetary claims against it and exhaustive research, because I'll just say this. My understanding, at least, is there's way more to consider and way more documents to go through in the Ripple case. So again, not to diminish the library case at all. I think it's of a high consequence, and there's a reason I've been covering it on this channel for sure. But think about attorney's fees to put all these papers together. Like sometimes a single document, I've heard estimates, I can't remember if it was from Hogan or Deaton or somebody else within the XRP community, but they're like, yeah, some of these documents, the time spent, all this, like a single document could be 10 grand. How many documents have there been? How many more would have to be created? How many more reports from these experts that Ripple had already previously paid to come to the conclusion that Dr. Metz's methodology was fundamentally flawed? So it starts to add up really quick, unfortunately. So that's what Fred had to say. And then there was this from Bill, member of the XRP community. He's another attorney, and he wrote, I am still feeling uneasy about a favorable outcome on the motion to oppose the new Dr. Metz report. It would be unfair if Ripple lost the motion, and I am not saying it will happen, but this is why it may happen. Number one, Ripple's lawyers concede on point 3 that the new report of Dr. Metz is important. Its subject matter is important and was one of the 3 matters Judge Torres specifically referred to in allowing the fair notice defense noting. That Ripple states that XRP's price bears no relation to Ripple's activity. So you're saying, of course, the argument is fundamental to Ripple's fair notice defense. It's crucial, so it might be allowed anyway. Point 2. Ripple reminds the court of SEC's previous delays and that it should not be rewarded for a further delay and breach of the rules. It seeks to outweigh the importance of the report by the unfair prejudice it will cause to the defendants if it is allowed. Number 3. This prejudice is expressed in terms of further delay and its impact on Ripple's business and causing it to use further resources. Number 4. As to delay, especially in terms of stifling Ripple's business, this argument has been made before by Ripple to oppose a motion of the SEC or prevent delay without success. Yeah, so we have seen this before. And I'll acknowledge that, certainly. And I think that the argument's pretty good. This is prejudicial against Ripple. This is materially harming their business, but they've made these arguments before. We have seen that before. It's worded more forcefully in this document. Again, I'm happy to see that. But we haven't really seen any success with that argument, and they're just bevying the same, assertion again. It's just... We'll see. And then Bill continues, as to using further resources, this can be addressed to some extent by an award of costs against the SEC, which Ripple seeks rather than not allowing in the report. And pause, think about that. So we're talking about, well, okay, we'll allow the delay. It's not good for Ripple's business, but we're not going to make Ripple pay for it. The SEC has to pay for it, which really means the taxpayer has to pay for it. Oh, yay. Oh, hooray. I just love it. Okay, that's sarcasm in case you didn't pick that up. Bill continues. Hopefully the court will see this delay as one too many and less excusable as discovery has closed and it interferes with the summary judgment phase of the matter. And it is quite an insolent delay by the SEC. Yeah, folks, think about this. We're at the final stages of this, effectively. You got to get ready for summary judgment here, the conclusion of this case. And they're talking about reopening discovery because of their own incompetence. Think about that. Really grinds my gears, folks. Bill continues. I read this statement by Ripple lawyers in the reply. The SEC has already asked the court for numerous extensions in this case that the defendants have vigorously opposed, as implying, stating, quote, which you have granted almost every time, but you should not grant this time, end quote. I am hopeful Ripple wins this motion, but ready to be disappointed. So there we go. And Fred Rispoli seemed to respond. Attorney Rispoli, he wrote, great analysis per usual. Your reasoning is why I think Netburn allows supplemental, but forces a quick timeline and makes SEC pick up the tab, which will not be cheap. So there we go. Straight to the taxpayers. Good times, everybody. All right, on to the next topic. Oh, yay. Don't you just love how the the outside of the XRP community, just the rest of crypto, by and large, just has no interest in what's going on in the Ripple and SEC case, pretending it doesn't matter, doesn't want to add any support, including associations like here you have the Blockchain Association. Where's the outcry? Look, here's the Blockchain Association's official Twitter account. And what did they write in the little space where you can describe yourself? They wrote, "The unified voice of the crypto industry." Oh, is that right? Are you unified with the XRP community? Are ya? Because I'll tell you what, we're under attack. I'll tell you what, we sure as hell are under attack. Jake Chervinsky, he actually he works at the Blockchain Association, head of policy over there, and he tweeted out the following just the other day. And this is a quote: "The novelty of cryptocurrencies requires novel regulatory policies, but the SEC still relies on the Securities Act of 1933, end quote. So that's a sentence from this report. And then Jake Chervinsky writes, "A fantastic paper on the SEC's inconsistent attempts to regulate crypto from my Blockchain Association colleague, Sarah Hamilby." And then they provided a link. So I looked at it, and I didn't read the whole thing, but you can do a search, press Control F, and you can search for keywords in here. There's no mention of Ripple, and there is no mention of XRP. And this was not lost on XRP community member Scott Chamberlain, who wrote the following on this. "Wow, a full paper on SEC regulatory uncertainty without mentioning XRP or SEC versus Ripple? That's quite an eye-popping omission for a U.S. crypto industry association. Does Blockchain Association only represent blocks and not ledgers? ... question mark." And I think he's being facetious there, obviously, because the XRP ledger is the XRP blockchain. If you look at, from a technical perspective, what the ledger is, it is a block. So you can just call it the XRP blockchain. For some reason, I don't know who decided in the earliest of days, the label that was assigned was XRP ledger. It is a blockchain. So there. So that's why he's saying, so you only represent blocks and not ledgers? Well, okay, of course. Now, attorney John Deaton retweeted that, and he had the following to say. "Bitcoin and Ethereum have represented 60 to 70% of the total market cap. People wouldn't complain if 60 to 70% of the effort was promoting and protecting those two tokens, but XRP was number 3 when sued. If the SEC wins, it will use the result versus other tokens. There's also library. Why so silent?" Excellent questions. I'm going to keep asking. Attorney Deaton undoubtedly will keep asking. So many of us in the community are asking. Nobody seems to give a damn. Although I will say, the one shining light on this front, and I highlighted this the other day, is that the Digital Chamber of Commerce, which is run by Perianne Boring, she actually did publicly tweet out that they're putting something together on the SEC versus Ripple case, which they did for the Telegram case as well. So hopefully it's good. We don't know for sure what's going to be in it, so I'm just cautiously optimistic. But for Telegram, if they do something equivalent to what was done with the Telegram filing, it will be good. So, cross your fingers. We'll wait. I'll cover it as soon as that's available. But finally, over a year later, there's an entity that's going to be filing something. What in the ever-loving hell? Some of these people, folks, I don't think it's rational, but some of these people really despise XRP. It's completely irrational. It's just a decentralized cryptocurrency, folks. That's it. They just despise it and they don't want to deal with it. I'll wrap it there, though. I am not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.